Joining me now, former Fulton County, Georgia Deputy District Attorney and MSNBC legal analyst Melissa Redmond, former SDNY Criminal Division Deputy Chief, former federal prosecutor and MSNBC legal analyst Christy Greenberg. MSNBC legal correspondent Lisa Rubin is here. Chuck Rosenberg is also still with me. Lisa, what does this mean for Jack Smith's ability to move this case forward?
It's a really interesting question and an open one, Chris. At the very least, it means we're going to see some hearings before Judge Chutkan in terms of at least 3 of the buckets of allegations here and whether or not they constitute official or unofficial conduct. But remember, one of the things that the court does at the very outset is to say he's certainly absolutely immune from one bucket of allegations, and that's with respect to his interactions with the Department of Justice. We know that for sure will be off the table, not only in terms of the charged conduct, but also in terms of what evidence can be considered at trial, because that is a part of this ruling as well. The court saying that anything that constitutes an official act for which the department does not overcome the presumption here, that also can't even be considered by the jury as evidence at trial, for example, of what the former president knew or what he intended to do. So I think to your question, what does this mean for Jack Smith's trial? It means a whole bunch of uncertainty, and the only certainty is that there will be some hearings ahead in terms of fact-finding for Judge Chutkan to differentiate the wheat from the chaff, so to speak.
Is it possible, Chuck, that case never sees the light of day?
Under the anything is possible answer foundation, yeah, it's possible.
Is it far more likely right now?
But I agree with Lisa and her analysis of the difficulties ahead for the prosecutors. There's no question that there'll be hearings below, that they'll be contentious, and that there'll likely be appeals from it. That said, can prosecutors fight their way through this? I think so. It's hard, and it's going to, but there will be some evidence remaining. Whatever the court below does, there'll be some evidence remaining that's purely private and therefore not immune. And there'll be some evidence in which the government can rebut the presumption of immunity, official acts that don't get covered. And so at the end of that, Chris, the prosecutors have a decision to make. Do we have enough? Do we have the quantum of evidence that we need to go to a jury and convince them by proof beyond a reasonable doubt? I don't know what that looks like, but can it go forward? We'll know more after those hearings, but I imagine they'll be left with not just something, but enough.
All right, Christy, let's talk about the Mar-a-Lago classified documents case. It has been indefinitely paused, waiting exactly for today, this decision. How do you think this will impact that case?
Well, it's not quite clear exactly how it will, because I think a lot of the conduct that we're looking at in that case happened after Donald Trump was president, not conduct that was in office. So in theory, it really shouldn't have much of an impact at all. But of course, given how Judge Cannon has approached that case generally, I'm sure, if anything, she will be even more emboldened by this decision to do her own analysis about the various acts in that indictment and whether or not anything is official versus unofficial. Again, it's based on this reading of the opinion, a very unworkable and unclear test or guiding principles, as you would say. We're not allowed to take into account whether or not what the defendant's motive is for engaging in certain acts to determine whether they're unofficial versus official. You can't even consider whether they would be illegal to determine whether they're unofficial or official. It's just whether or not there's any acts that could not plausibly be within the executive authority. It's not a very workable or clear test whatsoever. But I expect Judge Cannon to take a look at it and see if it applies to any of the allegations in that indictment and whether anything needs to be struck.
All right, Melissa, Trump's RICO case, Georgia, that's been paused as the state's appeals court decides about DA Fani Willis. But what do you make of this Supreme Court decision and how it will impact things there?
Well, Trump's Georgia attorneys made similar arguments as far as his presidential immunity in the Georgia case. And they filed that brief about a couple of months before the Supreme Court hearing. The state indicated it wanted to wait until the Supreme Court issued its decision and will be responding. So we'll see a similar hearing that Judge Chutkan will have to have, and Judge McAfee having to parse through the acts alleged to determine which ones are official, which ones were personal. Although Trump's attorneys did concede in their brief that the call to Secretary of State Raffensperger would have been personal. Those are candidate-seeking acts that would not be subject to presidential immunity. So the case in Georgia doesn't go away, but there will still have to be this decision of which acts will come in, which evidence will come in. Of course, some of those conversations with the Department of Justice would no longer be allowed to be overt acts in furtherance of the conspiracy. So the state would lose some of those overt acts, but we are talking about 140 acts. I think about 40 of them apply specifically to Donald Trump. So the state will also have to go through their indictment, go through their evidence, and see what they're left with and how to proceed with the prosecution of the case when it gets back to Judge McAfee. And then, of course, we will have the appeals of whatever he decides. It's another case that we will probably not see the light of day before the election.
You know, Lisa, we call this a decision, and clearly it is a decision, and it's a weighty decision just in terms of the number of pages. But it seems what it does is makes an ultimate decision, meaning a trial and a guilty or not guilty verdict, not just much further away, but so much more complicated.
So much more complicated. You know, when we had oral argument in this case, folks like me were asked to say what the impact would be of the various roads that they could go down. And I remember at the time thinking, in terms of the viability of a trial prior to the election, the outcome that we saw today was the one that folks like me and Chuck and Andrew Weissman would have told you at the time, and still would tell you, had the greatest propensity to further delay the ultimate disposition of this case and to further delay the ultimate disposition of two of the other cases we've talked about, the Mar-a-Lago records case and the Georgia case. Because in the Florida case, for example, Donald Trump is saying, I'm presidentially immune, and I was immune at the point in time where I took the records. Even though the charges against him, for example, have to do with unlawfully retaining the records, he will claim in that case that in taking the records to begin with, they were his. That was part of his exercise of a core constitutional province of the president. Well, under this decision, he's absolutely immune for that. You don't even need to have further fact-finding, whether it's official or unofficial. So this tangles up not only the federal election interference case, but those two other cases in substantial ways, assuming, for example, that the Georgia case survives this appellate proceeding with respect to Fani Willis's ability to remain in control. I expect this decision to have massive reverberations in all three of those cases, Chris.
So for people, Chuck, who say, I thought, again, non-lawyers, normal people, I thought the Supreme Court's job was to clarify, was to make understandable what the laws of this country are and what they mean. Do you understand if they throw their hands up and say, what?
I do. I'm not sure that the court sees its job always as to clarify. I think they often see their job as to pronounce. And here they pronounced, but that throws a great deal of uncertainty back to the district courts, not just in Mar-a-Lago, not just before Judge Chutkan, not just in Georgia, but for all, I mean, think about the other decisions we saw from the Supreme Court in the last couple of weeks, you know, upsetting the Chevron precedent, which has a lot to do with how administrative agencies determine regulations and how much deference they're owed. That's gone. It's a pronouncement. Now what happens? And so it's often left, not always, but often left for the lower courts to sort out these pronouncements. I get why people would be confused. I get why some would be angry. But often, not always, but often, it's a pronouncement and not a clarification.
All right, Christy, we've gone through the three cases that are still outstanding, but I do want to go back with Trump's hush money conviction in New York, because while that case has already been decided, and I assume this decision doesn't change that, the jury has had its say, could it have any consequences for the appeal Trump's team has talked about?
I'm sure they'll try, but they waived their ability to bring that argument. So it was not an argument that they made in a timely way. That's been ruled upon by Judge Merchan. So it should not affect his conviction in New York, but absolutely on appeal, they will bring this up, and we'll see. Again, most of that conduct, it would be very surprising if it was deemed to be official conduct, even under this Supreme Court's test, making the hush money payments, even though he was in the Oval Office, writing the checks to Michael Cohen to reimburse him for paying hush money to a porn star. It's hard to see any world in which that is deemed to be official conduct. So I think they would have a real uphill battle in trying to argue that.
Lisa, do you see any world in which that happens?
I do, but not in, I agree with Christie's analysis that with respect to the actual charges, they did waive their defense of presidential immunity. However, right before the trial, they asked the court to consider whether or not presidential immunity would be a bar to certain evidence in the case. Now, based on this ruling where you have the court saying that his official acts cannot even come into a case as evidence, that may be an issue for appeal because they wanted to exclude a number of tweets, for example, that former President Trump issued while he was in the White House that had to do with Michael Cohen, for example, or Stormy Daniels. They thought that that should be evidentiarily off limits. They may have a limited appeal just based on the admissibility of that as evidence, not about the totality of his acts that were charged in that case, Chris.
Lisa Rubin, I can't even take my mind there.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.